So, most of you know, this is Chantal Mak. Most of you have met her. And Christian confused her with her sister, which we all do. She's from, if you look at the PowerPoint slides up there, you wouldn't guess it, but she's from the University of Amsterdam, because all those buildings there, none of them are from Amsterdam. So it just tells you kind of Amsterdam's position in the world. I first worked with her in 2014. We taught a course at the Center for Transnational Legal Studies, the core course on transnational law. They gave me a choice of people to teach with, and she taught contract law and constitutional law. I'd never seen anyone who's done that before, and I'm talking to you two. And so I was really intrigued, and then I found out she knew more about both than I did. You've all read her, and I don't really have anything else to say about her. University of Amsterdam. We were going to write a book together, and she got a 800,000 euro grant from the EU to train judges on contract law, and she says, I really don't have time for a book. So I did the book anyway. Sorry, but I'm still pissed at that.
Sorry.
Anyway, Chantal, that wasn't the best introduction, but that's as good as you're going to get from me.
Thank you so much, Mike, and I'm very grateful for your invitation, and especially that you're still speaking with me after what happened to the book project. But I think it turned out to be a better book than it would have been with my participation. And I think that during this talk you will see how influential you were for my thinking about private law adjudication. And Mike is one of the reasons that I'm actually writing what I'm writing. And I'm also especially grateful that you gave me a chance to present here and a real deadline to finish my paper. So thank you so much. In this talk I'm going to present a bit more of the background to the paper and give a short summary, which hopefully then gives us lots to speak about. And I'm going to start a bit earlier than the paper does. So let me tell you a little bit more of where this paper originates from. Already since my PhD research, I've been working on theories of adjudication, then in particular regarding the impact of fundamental rights on contract law. And the three main theories that I've been exploring are the theory of adjudication of Ronald Dworkin, Jürgen Habermas's discourse theory, and then the critique of adjudication of Duncan Kennedy. And I'm not going to go into them in detail now, but what I found challenging is how they apply to Europe. And this particularly brought me to what we see in terms of judicial interaction in the EU. Stefano Rodotà, lawyer and politician from Italy, once said that judges are making Europe, especially when politics are not speaking. He made this reference in regard to the EU Charter of Fundamental Rights, of which he was one of the drafters. And his observation was related to the fact that the EU Charter of Fundamental Rights was used very actively by judges to make new rules of law. And he said that they were doing this in the silence of politics because the legislature was not stepping in to regulate certain issues. And this observation resonates very much with me, because when I look at the field of private law, then I see something similar happening. So with private law, here I mean a very broad term covering contract law, tort law, family law, company law, as distinguished from the public law that regulates the relation between public authorities and citizens. So private law in Europe is about the interaction between private actors. And when we look at that interaction, we see there's a plurality of sources and actors, because we have national systems. So in the civil law tradition, we have the civil codes. In the common law, the development of private law by courts, and a variety of actors, both in terms of the parties who interact in private legal cases and the institutions that deal with them. So both legislation has different levels. There's national legislatures and the EU legislature, and also adjudication has different levels. And this is where it got difficult for me to rely on the work in Habermas and Kennedy's critique to understand private law adjudication. Because when we see judges at different levels of governance interacting, then these theories do not provide full answers, especially because most of them have been written for communities, especially private law communities, that correspond to nation states. In the same way, when we look at discourse theory, we can say that in Europe there's a plurality of spheres, of public spheres, and I rely on that a lot in the development of my theory. But that also means that these do not necessarily overlap with one nation state or with Europe as a whole. And there's, or at least my colleagues in communication science would say it is not empirically proven that there is a European public sphere. And then there's a plurality of values, and this also means that if you accept Kennedy's critique of adjudication, which says that private law is not neutral and might look very technical, but there's always legal political stakes in the rules of private law, then this multiplicity of levels of governance means that we have to relate to how these values and eventually also conceptions of justice relate to one another. So this brought me to my question, what is the role of courts? How can we understand and justify what courts are doing in this field of private law in Europe? So, as Mike said, indeed I got a grant that allowed me to look into that, that actually allowed me to hire 2 PhDs and a postdoc, and to explore further what is the role of judges. I called this project Judges in Utopia. This is not based on Thomas More, and it's often a misunderstanding on that, but it's actually from a quote by Habermas, who said that in national states, to realize the social values, we rely on the institutions, of the constitutional institutions, to realize a realistic utopia. And that's my impression, that he might actually have been inspired by Rawls, who uses the idea of a realistic utopia in his thinking of the way that justice operates in societies. So Mike already invited me one time before, in 2015, when I spoke at this workshop on the private law constitution. And there I asked the question relating to this project, is judicial lawmaking a first or a second best solution? And in particular, I relied on a Habermasian theoretical framework to start exploring that. Now, my main recollection of that seminar, and Mark just confirmed this, is that all participants tried to talk me out of using Habermas as a theoretical framework for this question. And as you might have seen in the paper, you did not fully succeed, but you did get me thinking about this more. So how could Habermasian discourse theory actually help us understand the role of judges in European private law? So I'm very happy to be here again and to continue this conversation. So the project finished in 2019. 2 wonderful books by the PhDs came out of this. Anna van Duin's book on effective judicial protection in consumer litigation, and Lara Burger's book on the democratic legitimacy of judicial lawmaking in Europe, in which she particularly looked at climate change litigation. And this summer in July, an edited volume on civil courts and the European policy will be published, in which there's also an excellent chapter by Mike. So, these were all very good results of the project that provided more insights. Yet I still had the ambition to write down my overarching view. And this is what I tried to do in this paper. So here I tried to work further on what the theory of European private law adjudication could look like. And I will now briefly explain different parts of the paper to facilitate the discussion. So the methodology could be comprised in what is called New Private Law Theory by Stefan Groenman, Hans Miklitz and Moritz Renner in a book they recently published. So I was very happy when I saw their book, because actually what they describe as New Private Law Theory very nicely fits what me and many of my colleagues have been doing in our research. And their main claim is that private law theory should be pluralistic, so it incorporates insights from different legal theories as well as other disciplines, in particular economics, sociology and philosophy. It's comparative, so we look at the interaction of different legal systems to learn more about private law. It's application-oriented, which means that it should actually have a bearing on legal practice. It's not theory for the sake of theory, but it should have something to say about what we see happening in private law. It's not state-centered or exclusively national, but it looks at the transnational elements of private law as well. And it reflects critical approaches to law. I can say more about this in the discussion, but just as a framing, this is what I feel my research resonates with. So then a little bit more about the field of European private law. Not only for the present audience, but also in Europe, actually, the field is still the topic of debate, because we do not have a European civil code. So actually in Amsterdam, there's one of my colleagues who works in administrative law, and he always jokes that I'm doing research in a field that doesn't really exist, because it's not codified. But yeah, I think European private law is now widely accepted in academia as a term that captures the rules of private law that govern relations within contract law, tort law, and different aspects of private law that are regulated by this interplay of national and European rules. So if we look at specifically contract law, we can see academic movements starting in the 1970s, when Ole Nando, a Danish professor, started thinking about principles of European contract law. And interestingly, his background till then was mostly in private international law, which looks at the question how to deal with cases of private law in which there's different elements from an international background, and then to how to establish which court is competent to hear a case and which law is applicable. And then his thought was, wouldn't it be much easier, especially for commercial parties, if there were one set of principles of European contract law that they could apply to all their dealings within Europe? This led to development of principles of European contract law, together with other academics from many different European countries, that were published in around the year 2000. And at that time there was also a lively discussion on the question whether we would be moving towards a European civil code. At that time there was a lot of Euro-optimism, and especially on the European continent people were thinking about further codification of contract law and perhaps even private law as a whole. This was also supported by the European Parliament, and the European Parliament called upon the European Commission to start looking into options for legislation. The European Commission then supported the work on a draft common frame of reference that could serve as a model for a European civil code. And this was presented by the study group on the European civil code and the group on the acquis communautaire in 2009. Well, if you look at that year, then you can already imagine that there was a kind of turn in the optimism about Europe, because that was the time when the consequences of the economic crisis became visible, and the European Commission also had other things to do to think about harmonization of private law. So eventually it narrowed down its initiatives in the field of private law to a proposal for a common European sales law that would govern sales contracts in Europe. But even that lost its momentum when several member states started raising objections, and then there were so many amendments to the proposal that the European Commission in 2014 put it on a list of proposals that would be amended or withdrawn. And then nothing happened with it anymore. So Hans Miekliet wrote on this, and he compared the process of further harmonization of private law to that on the European Constitution, which was around the same time, and he called this the failure of two grand projects. Although failure is not in the sense that there's no follow-up, but there's no formal constitution nor a formal civil code. So we're now at a stage where European private law is still a combination, like a patchwork of different European measures. In particular, the European Commission has been very active in regulating the digital market and national private laws. And that's the background to which judges do their work, and in specific private legal cases they have to combine rules of EU law with national rules in order to find solutions for private parties. Now, if we look at three examples in particular, we will see that it's not very easy for judges to deal with that, and that there's also a quite pronounced political dimension to these cases. So one that I've already discussed quite extensively with Mike, and that I believe is also an inspiration for your work, is the case of housing, where the Aziz judgment in 2013 was the start of a whole series of judgments of the Court of Justice of the EU on the way that mortgage contracts should be assessed. And I should say here that the EU itself does not look at mortgage contract as a whole, but in particular the Unfair Terms Directive has been very influential in assessing these type of contracts. And the reason why it's become so important, also as an example in this study, is that the case of the Court of Justice quite significantly changed the way that national systems had to deal with unfair terms control. And so in Spain, where the Aziz case originated from, it actually induced a reform of national procedural law, requiring judges to already, at the beginning of enforcement proceedings, assess the fairness of contract terms. And in other countries, in Poland primarily, there's currently a debate on consumer credit contracts. So after the mortgage cases, there came a line of cases on credit contracts regarding the terms of credit contracts in which the currency of the loan is established in a different one than the national currency. And especially in Poland, this has raised a lot of discussion because there are many people there who have credit contracts in which they have to pay back the amount of the loan not in the Polish currency but in Swiss francs. And then if the currency changes to the detriment of the consumer, it means they're paying much more than what they initially got from the banks. So there's a lot of debate on how the national courts should handle this. A second example that is currently being debated is about non-discrimination law and employment. There's been a series of cases at the Court of Justice about neutrality policies by companies. So these are company policies that prohibit their workers from wearing manifestation of their faith. And the Court of Justice's case law is quite controversial in this point because it gives a lot of weight to the company interest to freely conduct their business. And they do so because it is also a right protected under the Charter of Fundamental Rights. So Article 16 of the Charter protects the freedom to conduct a business. And even more than, the court says the company may take into account the wishes of their customers. And so some of the more recent cases were about women working in daycare facilities who wished to wear a headscarf at work. And then the court said that the company could take into account the wish of parents for their children not to be confronted with different manifestations of religion. Now, as you can also read in my paper, there's a lot of discussion about this, also the question whether actually diversity or people getting familiar with different religions is served by these kind of policies. And then the last case I selected for this paper is climate change. So this was the topic that Laura Burgers chose for her thesis. And when she chose it, the first judgment in the Urgenda case still had to be handed down, but since then it has become a huge topic. And I know from Mike, but also from Laura, that also in your university you have an excellent group working on climate change litigation. So why it's so interesting for the role of the judiciary is that we see that although these cases are mostly based in private law, so in tort law, there's an influence of human rights there. So here I step outside of the framework of EU law for a moment and I look at the influence of the European Convention on Human Rights. And all EU member states are also members to that, or are parties to that convention, so it's interesting to look at the comparison. And we see that national courts have already recognized positive obligations of states under the convention to do more to reduce greenhouse gas emissions. Articles 2 and 8 have been a basis for that in the Dutch Agenda case. And so the right to life and the right to a clean environment have been recognized by the Dutch Supreme Court as a basis for liability of the state. And in a more recent judgment, this was also a basis for recognizing liability of a big company, the oil company Shell. But I must say the Shell judgment was won by the district court and we're still waiting for the judgment in appeal in that case. Then there's also cases pending at the Court of Human Rights. So last week it was in the news that there was a hearing in 3 cases. One was about Swiss senior citizens who were claiming that their government should do more against climate change because especially older people would suffer the consequences of climate change. Then there was a French case which regards a municipality that's on the coast and that is in danger of being flooded because of climate change. And there's a Portuguese case brought by young people who fear that because of the wildfires caused because of climate change, their living environment will be endangered. So, and we see a lot of movement here, and again I think it's an excellent example of the way that private law is being used by actors to bring court cases to raise attention for a topic. So as you might have seen, I've chosen these cases not randomly, but especially because they kind of force courts to engage with matters that we usually would expect the legislature to address, politically sensitive topics. And then the question that I raise in the paper is, why have they been allocated to the courts? And so why are courts dealing with this? And can we find a justification for this in private law theory? Then very briefly, I look at 3 different perspectives. The first one is social justice. And so already for I think about 20 years there's been a debate on social justice in European private law. And the main argument is that we should look at private law not only from a perspective of corrective justice between the parties, but also look at its distributive consequences. And I'm sure we will speak more about it also tomorrow. Very much looking forward to that. So this has been a very influential strand of scholarship that was particularly inspired by the Manifesto on Social Justice published in 2004. And in the paper I describe several academic responses saying that it has been quite successful. It has managed to put social justice on the agenda of the European legislature, but there's also more work to be done. And the horizontal effect of the Charter might be one way to raise more awareness and to do more about questions of distribution in private law. Still, for me, it does not answer the question on what is the role of courts. And so it can explain what case law can do and how case law can contribute to questions of redistribution, but it does not fully answer the question why courts are dealing with this and why not the legislature. So there's 2 aspects that I highlight here. One is that the justice deficit of European private law is not fully addressed yet. So then I think, for instance, of how the law regards vulnerable groups, how lifetime contracts, so for instance, mortgages, employment contracts, and so contracts that people need to fulfill basic needs and that mostly run for a very long time, how these are governed. And then also questions of sustainability, perhaps the topic of today. So my view is that this perspective, at least as it has been developed till now, does not give full answers to how courts should deal with these aspects, and particularly how the case law deals with inclusion of specific groups. A second perspective that I then looked into is constitutionalism. That's where Mike's work was also very inspirational for me, and what we had a lot of discussions on since our time in London. So then the question is, if we take a constitutional perspective on private law, what does that mean for the role of courts? Well, one question then is that of authority, so who decides, and the question of competence, namely who has the ultimate authority to decide on a legal question. And here I build a lot on constitutional pluralism, arguing that for private law, a pluralist view could also give principles that decide in which cases the national courts has the ultimate authority, and in which cases the European courts can intervene in national private law. But one thing that I find difficult in this discussion is then where the substantive dimension comes in. And so in private law we very often focus on the substance, what is the remedy. Anna van Duinen has written on this, and also the relation between procedure and remedy. And if we look at pluralism, very often there's more emphasis on institutions and procedures than on the actual substantive outcomes. So this is one question that is still open. The second part of the constitutional question for me relates to what political community is governed by private law. And this then again relates to this question of plurality. So in European constitutional theory there's a lot of debate on the extent to which Europe can be called a polity. And for me the question is also to what extent national communities can contribute to that emerging European polity. For instance, through the concept of dual citizenship that Habermas has proposed. Now again, this does not fully answer the question, what is the role of civil courts? And in particular, as I argue in this paper, this has to do with the question where discourses of justification take place. So Habermas in his work distinguishes between discourses of justification and discourses of application, where justification mostly takes place in legislative process. So the arguments are heard by the legislature, and on the basis of the political debate, new rules are enacted. And discourses of application are then the discourses that take place in adjudication, where the court hears all the parties and adjudicates the case according to what are the best arguments within the legal framework. But if we look at transnational processes, then my question is, are these cases really only about application? If we look at housing, non-discrimination and climate change, then arguably the interaction between the courts is about more than just the application of the current rules. And for instance, if we look at the Aziz case, we see that the Court of Justice pronouncement on unfair terms assessment brought about significant changes in national legal systems. So there we could argue, isn't this actually a process of justification of new rules that's going on? So then, there he is again, Habermas. You did not convince me to fully let go of this theory, but Mike, you did convince me that I also had to look at the work of Nancy Fraser. She was one of the authors that you assigned in the core course in London at the time. So, actually, I think one of the headings in my paper should be "Thank you, Mike." Because a lot of what I wrote is inspired by the literature that you brought to my attention. And I think Nancy Fraser's work on transnationalizing public spheres, but also on scales of justice and building on Habermas and also entering in conversation with Habermas, for me also inspiration for looking at the role of courts. And I agree with you that it was not enough to just look at Habermas, but I needed something more. And I hope that this something more can convince you to some extent. So from Fraser, I in particular take the idea of democratic inclusion, that there should be a possibility for everyone who is governed by certain rules to have a say in how they are enacted, and that if we look at the law beyond the nation state, we have to ask ourselves the question, how are we going to demarcate the scope? And so who is involved and who gets to have a say? Nancy Fraser then makes a distinction between the principle of all effectiveness and all subjectiveness, eventually arguing in favor of the latter. And so all affected would be anyone affected by certain rules. But as she says, if you take the logic of the butterfly effect, by which everyone would be affected by everything, then that's not the demarcation of the scope, and then everyone would have to be consulted. So she then opts for the all subjected principle, which means everyone who is subjected to a certain sphere of governance should have a say in the rules that are enacted within that sphere. Well, also that notion has its drawbacks. I go into that in some length in the paper, but I think one advantage, it's not limited by citizenship. And so citizenship is one ground because of which people can be subjected to a certain sphere of governance, but all subjectiveness is not limited to that. And I think for private law theory that is a very important notion. And I think again the Aziz case is a good example. So Mr. Aziz was from Moroccan origin and concluded a mortgage contract in Spain. So although he likely did not have a way to influence the legislative process, he could bring a case to a court, and through his case, Spanish law was profoundly reformed. So here we see that, and there's different ways in which then legal subjects can participate in lawmaking processes, but in this particular case, it's not even a dual trajectory where someone would be both a citizen participating in the legislative process and then, as a participant in a case, be an actor in the adjudication of a case. But here it goes through adjudication. So legal change is brought about through adjudication that has a broader scope of people who are included. And then the notion of a public sphere, in my opinion, still remains relevant, even though there might empirically not be a European public sphere. But I think these cases, and they create specific public spheres, or maybe not create, but they maintain a sphere in which the legal political stakes behind topical questions such as the housing crisis, the environment, and non-discrimination are discussed. And in the paper I provide some examples of where these debates take place. So then, and I would like to draw particular attention here to the picture.
Okay.
Mike, yes. Here we see a group of people at the court in The Hague, where a judgment against Shell was pronounced. So here, I think we see a manifestation of my main claim in the paper, namely that it's not so much a linear process in which adjudication contributes to enacting further legislation, but we see certain cycles happening where legislation generates case law, which in its turn influences legislative processes. And the case law then, apart from providing an answer between the parties, in the cases that I selected, I view a certain impact on the prioritization of topics on the political agenda. And for climate change, there's actually a lot of academic literature that backs this up. So people have been pointing out that even if climate cases do not succeed, they have a function in raising a public debate, and therefore also the intention of the legislature to do something about climate change. And I think arguably for housing, for non-discrimination, and for other politically sensitive issues, you could say the same. So it's not only about putting the topic on the agenda, and many legislatures are already thinking about these topics, but it's also about bringing them to a higher point on the agenda. So actually, and by raising the urgency of doing something, arguing for the priority of these issues in legislative processes. So this then brings me back to the question that I asked, so what is the role of courts in private law in Europe? And I think I could summarize it as such that European private law adjudication is about transnational communities rather than one national community or one European community. We see the interaction between different communities around different topics. The same can be said for public spheres. So these cases, they maintain public spheres in which the political stakes in these questions are discussed, and as such raise specific questions to the legislative processes, both nationally and on the European level. And to some extent they can mend the justice deficit in Europe. So by providing specific remedies, for instance, in housing, I think this is very clear. They can contribute to a sense of justice in European private law. And then, my main claim, which when I was reading through the paper is maybe not that explicit, so I should make it more explicit in a next version, is then that EPL adjudication is not only a form of a discourse of application, but in my view it could be seen as a contribution to discourses of justification. So with this I conclude. So maybe I didn't mention this yet, but this is the first time I present the paper, so any feedback is very, very welcome. Anything can still be changed or added. And I'm going to present it next month in my own research group and then submit it to a journal. So any comments are very, very welcome. And in particular, I think an aspect that is still something that maybe I could clarify more is what is the analytical and what is the normative dimension of this theory. So to what extent this is an analysis of what is happening, and to what extent could I also argue that this is normatively how it should be. And if the latter, then I would take a stronger stand than I did in the paper I presented here earlier, namely that adjudication could be a first best option under certain circumstances. So the question mark would disappear. It would be a first best option. And with this, I thank you for your attention.
Okay. Because I want to get the clapping in for the camera.
Ah.
Okay.